That's 1, 2, 3. All right. Good morning. I hope everyone had a okay commute. Not too bad. All right. I think it'll be a little bit trickling, which is fine. For those of you on Zoom land, hello. Hello. Hope you're all safe. Uh, a new piece of tech. I got a wireless Bluetooth mic. Let me know how it sounds. So the upshot is it follows me. So if I stand over here, you can actually hear it. Do you still hear me on Zoom? Hear me? Hear me? Maybe. I don't know. No, the reason I've wanted this, it's actually my razor. I've wanted this for years. It didn't exist till about a week ago. I bought it immediately. I'm serious. I'm serious. I used to actually carry around. It was awful. A mic attached to my phone. I would just carry it everywhere I went. Which is, you'll see old videos. I'm carrying my phone. Why? Because the mics. But this is now anyway. So I'm happy with it. See how it sounds. I tested at home. Sounded okay. Don't know how it sounded in here, but if it sounds okay, that will be useful to know. Okay. All right. Okay. So I hope you all had an enjoyable spring break. I met with a lot of you. I was pleasantly surprised. I think the way I did the midterm this year actually worked better, and I'll just inside baseball. What I used to do in the past was I would give the midterm the day before spring break. I would spend the entire spring break grading the midterm, and then I spent a month going over them with students. And the problem was there were some students who actually needed help, and I didn't see them until like mid-April or late April, and there was a lot of a gap. So I tried this year of having grade yourselves, and do you want to know what? You guys are pretty accurate. I'm sure I'm not just like trying to puff you up. The grades you gave yourself were within maybe 2 or 3 points what I've given you. So if you gave yourself a 32, maybe you've been a 34, maybe a 31, but like you were in the bar. Whenever I was, yeah, that's about right, maybe plus or minus. So actually, this was surprisingly effective rubric help. Also, you didn't do it as afraid. You didn't inflate yourselves, which I was worried like, oh man, I got 100. No, none of you did that. You were actually, I think, pretty honest with yourself, which is always good. Be honest to yourself, be true to yourself. And when I met with you, it was actually meaningful because you had just taken the exam and it was fresh in your head. Right. The other bad part is when I gave you an exam in March and went over in April, no one remembered. It's like, I don't remember what I did. So if you do it a couple days later, it's fresh. I'll be in my office today. Right after class, you want to come up and chat? I'm happy to talk to you. And we can do it during office hours, right? So there might be a little bit of a long line. I apologize in advance, but it's the best way of doing it. Yeah, but any just thoughts on the midterm review process? I'm always open to what you think. So I always try to make things better for next year. Always thinking ahead. You guys are gone, but you're no. It's a weird thing, right? Because like these things, like, oh, next year I'll do it better. You don't care. It doesn't affect you, but I do. I care. So any thoughts of how I can improve it? Think that work better or worse? And actually, the time slots starting earlier in the day with different grades, I think worked actually better because I was able to make sure the queue wasn't too long for people who may have done a little bit worse on the exam. No? Okay. If you've read the syllabus, you'll see there's no class on Thursday. I am going out of town. I have a big thing in DC on Thursday. I'll be doing something else tomorrow morning and got some stuff to do. I'll tell you about when I get back. All right. Anything else in your minds? All right. So the good news, we are done with future interests. Yeah, you can clap. Please clap. Thank you. The hardest part of the semester is now behind us. Now you can't forget it. If you look at my final exams, there are always several future interest questions. So you can't just like bury it, in your mind and say, okay, never. When I was in the 7th or 8th grade, I had a kid in my school. We were reading a book, and after I read a page, he actually ripped the book out of the page. And so we got to the end of the book, it was just the cover. It was just the two covers. And I don't know why. I was like, yeah, that's it's over. I don't have to do it anymore. I read that page already. So don't do that, right? Don't just rip out the future interest pages of your casebook. You got to remember it. Throughout the semester, I'd encourage you, like every week, do a future interest question. Just go through my old midterms or go to the book. Just do one. It's like you don't want to forget it, because if you try to reteach it yourself, like in like late April, final now, and just anyway, that's the way the semester works. Some schools do what they call compressed courses. So instead of having a class meet twice a week for the entire semester, it meets 4 times a week for half a semester. And basically, the halfway point to your midterm is your final, right? So you basically compress a semester, and then you do another class the second half of the semester. So you anyway, maybe there are pros and cons. It's fresh in your mind. I don't know. All right. Any other questions? Okay. So we're starting a new topic today called concurrent interests. Concurrent interests. All right. I apologize. I put on the case summary page sort of a guide to concurrent interests. I forgot to do it last night. I just completely slipped my mind. So I put it there this morning. If you didn't get it, that's fine. But try to review it after class. I sincerely apologize. Let's look at a couple examples, right? Make this a little bit bigger. Example number 1, we've done 100,000 million times, it seems, right? Poor Alex keeps dying. I think it's the last time he'll die this class. I think you're good after this one. From O to A for life, then to Baker and our heirs, right? Of course, Alex is a life estate, then Baker has the remainder, best remainder in fee simple. But we always said to this point that there's one present interest at a time, which is true. There could be one present interest at a time. But what's significant here is only one person has that present interest. A, right? It was always A has a single present interest, right? We call these interests consecutive interests. Consecutive interests, right? A has the present life estate, and B has the future interest, invested remainder. Consecutive interest. Example number 2 is different. Example number 2 is what we call concurrent interests. Concurrent interests. I think you'll know, but I'll just clarify. Consecutive means one after the other, right? Number 1 to number 2. Concurrent means at the same time. This is great. I know my voice is following me. I don't have to worry about it. You don't realize this. I actually wear at the microphone. I try to stay too far with the mic because I try to make sure there's anyway. It's liberating. It really is. I considered having a 20-foot cable, but I would trip on my butt and it'd be ugly, right? I considered having a long wire and I decided against it. Okay. Concurrent interests are where 2 people at the same time have a present interest, right? With concurrent interest, actually it's 2 or more people, not just 2. 2 or more people can have a present interest at the same time. All right. They're with me so far? All right. There are 3 kinds of concurrent interest. There's 3 kinds of concurrent interest we'll cover today. The first is called the joint tenancy. The joint tenancy. The second type of concurrent interest is called the tenancy in common. The tenancy in common. Okay. The third type of concurrent interest is called the tenancy by the entirety. The tenancy by the entirety. Okay, these are the three types of concurring interests. Let me make one point very clear. A lot of you may have roommates, right? You have an apartment, you have a roommate, you have two roommates, etc. That has nothing to do with this topic. Leaseholds, right? You all have leases for your apartments. Leaseholds are a completely different area. We'll cover that later this semester. Do not confuse a lease between two people with a tenancy in common. This is another kind of fee interest, right? It's another kind of fee interest. Same with a fee simple, etc. A life estate. These are fee interests. Leaseholds are different. Don't get tripped up. Don't say, "Oh yeah, my room and I were tenants in common." That's not how this works. I'm giving you the warning, right? You will make this mistake on the exam. I'm telling you, you're going to do it. You do it anyway. Do not confuse tenancy in common with co-tenants in a lease. It sounds so similar, right? Oh, it's my co-tenant, right? Don't confuse it. You'll get yourself tripped up. Okay? I warned you. I'll warn you a couple more times. You'll still do it. But that's the nature of this gig, as they say. All right. So let's start. I'll go a little bit out of order from the book because I don't like the way the book does it, but it's the best we got. And let's look at example number 2. Okay. Let me put this up here so your notes are in correct order. Okay. So example number 2, it says Blackacre from Ollie to Alex and Baker as joint tenants. All right, so let's just walk through this. Okay, I have no idea who I'm up to. Does anyone actually remember? Well, 2 people with their hands up. James, or is it Max? Who is it? Okay. Well, I mean, you're up in 2 slots anyway, so it's no. Who's actually next? I don't want you guys to game it. Is it you, James? Okay, Crespin, do you concur? Okay, but Max, you'll be up in a moment, so don't worry about it. I gotta try to keep this fair. All right, James. So let's just look at this example for a minute, right? You see, it says Blackacre from Ollie to Alex, and Baker as joint tenants, right? Who has the present interest here?
Alex and Baker.
Okay, that becomes a harder question. Who has the future interest here?
The one that doesn't die.
Well, that's a good answer. Does Ollie have any future interest here?
No.
Okay, that's correct. All right, good. Whenever you look at these questions, always sort of ask yourself, who has the present interest, right? And who has a future interest? If this had just said, from Ollie to Alex for life, period, we know that O has some sort of reversion, right? Some sort of future interest. It comes back to O. But in this question, in example number 2, Ollie gave away his entire bundle of sticks to Alex and Baker. So this is an unfamiliar concept where the same person can have both the present and the future interest. Again, let's see that one more time. It blows your mind, right? The same person has both the present interest and the future interest. Now we don't know which one though, right? Let's just think of this in general. Okay, so I got James. Who's that behind James? I can't see your name tag. Hayden. Okay, sorry, your name tag was hidden. So I think James said the one who doesn't die first, right? Just walk through. How does this work, right? Let's just say in this question, Alex dies. What happens into Blackacre? In. Okay, that's correct. And what happens if Baker dies first? Okay, so but wait a minute. Which one of them has a future interest? Is it Alex or is it Baker?
Because it depends on things that on who dies first.
That's correct. This is what's called in property a right of survivorship. A right of survivorship. In example number 2, there's a right of survivorship. It's not that Baker has a future interest and Alex has a future interest. It's going to be or, right? One of them has it. We don't know which one. And the way in the law we describe that relationship is called a right of survivorship. whoever survives has the right to Blackacre. All right. So they both have a present interest, and they both have right of survivorship. So you're all used to saying, you know, B has a future interest in remainder, et cetera, et cetera, et cetera. You got to use a little bit different language here, right? What we say is that A and B have a right of survivorship. They have that together, something they sort of share. And whoever actually survives from the two of them will keep it. Okay, Amara, we're doing looking good? Good. Everyone with me so far. So let's just write out on number 2 the sort of interest we have. Okay. So Max, how would we describe the present interest? Just how would we describe it in words? Yeah, be a little more precise. Well, read it. What does it say? Close. Okay. So the present interest is a joint tenancy, right? But Max, why do you say it's in fee simple? Doesn't fee simple mean forever and ever and ever? Can Baker or Alex decide what happens to Blackacre after their death? No. What happens upon the death of one of them? Okay. We said now from the get-go of this class, the very definition of a fee simple is you can control the future interest, right? You can control what happens to Blackacre after you're dead. But in this example, number 2, that's not the case. Alex cannot control what happens to Blackacre after Alex's death. And Baker cannot control what happens to Blackacre after Baker's death, right? They have no control on this matter. So instead, what we have is a joint tenancy, which I think Max said, right? The present interest is Alex and Baker are joint tenants. And that's how we sort of write it, right? And I mean, it's right there in the question, right? This is as joint tenants, but you have to know what that means. Alex and Baker are joint tenants. That's the present interest. Okay, Stephanie? What is the future interest in example number 2? That's correct. What? Oh, say again? Okay. All right, let's just break down. Okay, you're exactly right, okay? Okay, so here we have, upon the death, so Stephanie, let's walk this through. Upon the death of A, who gets it? Good. And now, if B dies first, who gets it? What do we write that they possess? Correct. So we say that Alex and Baker have a right of I can't spell survivorship. There, I think I spelled that right. Okay. Alex and Baker have a right of survivorship. Now, Stephanie is exactly right. What that means is, upon the death of Alex, Baker would own Blackacre in fee simple, right? And upon the death of Baker, Alex would own it in fee simple, right? So I would encourage you. I think both Max and Stephanie try putting the word fee simple into the answer here. Resist the urge, right? So I'm trying to say the class today is a little bit different lingo than last week. 1 second, Jen, see you, right? Don't say the present interest in fee simple. That's not quite right. And don't say the right of survivorship in fee simple. That's not right. What it actually means is whoever lives longer gets the fee simple. We don't describe it as fee simple in just a label. That makes sense, Stephanie? Mac's not here, but okay. Janice, saw your hands up a moment ago. Okay, so the terminology is a little trickier. So how did you say it one more time? You could say that, yeah. This is just an alternate. I'm just giving you, because what Jen said is correct. And so if you see this elsewhere, make sure you have your notes are complete. Okay, so was that your question, Jen? Yeah, that's actually better than what I wrote. So yes, thank you. Has a future interest in restaurant. Yeah, I think you're actually, it makes me happy when students correct me because that means you're really like paying attention. So that's actually it's like a good thing. So yeah, okay, all right. Everyone with me so far. But the key point about the joint tenancy is includes the right of survivorship, right? This is like the most valuable feature of the joint tenancy. You're basically stuck with this other person with the redeeming value that maybe if you outlive him, you get it be simple, but you're stuck with him for life. All right. So I'm gonna just blow your mind just for a minute, but you're gonna see an example like this later, maybe next class. I can't remember when it comes up. Blackacre from Ollie to Alex and Baker for their joint lives. You're going to see that example. I think this class was next. I can't remember which one it was in your book. Ollie from Alex to Baker for their joint lives. This is a little bit different, right? Example 2 is different than example 1. I'm sorry, than this example. What's going on here is that you have back-to-back life estates. So let's say Alex dies first, then Baker keeps it for his life. When Baker dies, where's it go? Back to O. All right. If Baker dies first, Alex keeps it for his life. When Alex dies, it goes back to O. Right? Don't confuse this and this, right? Because O gets it back eventually. But with a joint tenancy, O never gets it back, right? O has no future interest. So just to make this point clear, on an exam, if I said identify all the present future interests here, you would need to say that O has no interest. A couple of you sort of tripped that up in the midterm. Make sure you account for each person who's in the question. If I mention O, just say O has no interest, and you get your credit. Like don't leave those points in the table because a lot of you just missed a point or two here and there for those questions. Okay. All right. All right. So I'll show you something funny. This is actually a plaque in my house. So my daughter drew on the wall in crayon. It was actually like the entire wall, right? And we thought we could either remove it, we could frame it. So we basically just put a frame around the crayon drawing. And and I had the smart ass idea of just putting a plaque on the wall. So I actually had a little plaque made and we attached it to the wall. And I basically created a conveyance. So my oldest daughter's Miriam, and Miriam gave the painting to us, her parents who own the house, for our joint lives, and then to her sister. So the sister has the remainder after we're dead, but we have a joint life estate. I swear this is true. It's actually it's my hallway. So and I called it to the walls because she drew over the walls in crayon. Uh, let me find it. Hold on, where is it? No, I know. It's I wasn't planning to show it. Oh, here it is. Yeah. So yeah, that's it. I mean, like I was just sitting around and I heard like, what's that? Like a scratching sound. And she used different color. It's actually beautiful. I don't think art people, but like she made it in roughly the shape of a canvas, right? She basically kept a sense of proportion. So I was like, we could erase this or just frame it. So I said, screw it, let's frame it. Um, but the important point is, uh, you know, we created a joint life estate per parent, so that way we can keep it at least for our lives. Now, as her guardian, we can actually do this on her behalf. We can create a future interest for her work because she mixed her labor with the wall. You don't want to be my kid. It's probably bad. They'll be nerded out by the time they're like 2. Okay, all right. So I wasn't planning on showing that, but there you go. All right, what else? All right. Oh yeah. So don't confuse a joint life estate with a joint tenancy, right? They're not the same thing, and people often do get them mixed up. Yeah. All right. So again, on example number two, the present interest is a concurring interest. It's a joint tenancy, right? And I think the way Jen said it is just fine as well. The future interest is called the right of survivorship. Whoever lives longer will in Blackacre and fee simple. But only one of them will ever actually get that future interest, right? Which is why I encourage you to write this way. Don't say that Alex the future interest and Baker is the future interest. It's kind of a joint thing they share together, right? Right. Now, again, be careful. Do not say that Alex and Baker have life estates, right? There's a difference between joint tenants and joint live, which is why I showed you that little plaque on my wall. My daughter will understand that when she's 3, right? Um, there's a difference. One of my other students in other sections said she wants to bring a kid to school today, so we'll see. I'll call them, see if they can figure this one out. We'll see. I've a couple years ago, I was teaching a class in common law, First Amendment. It was a class where there was a lot of cursing involved, and one of my students brought their kid to class. And I was dropping f bombs the entire class, and then so that's how it goes. Yes.
You have to mention, or can you mention that I have equal undivided interest?
I'm not there yet. I'm not there yet. I will get there. I'm not there yet. So say out of order from the book, but I will get there. I promise. All right. Everyone okay with the joint tenancy so far? All right. Let's do example number 3. Okay, it says, it's for Kylie. So it says Blackacre from Ollie to Alex and Baker is tenants in common. So Kylie, same question as before. Does Ollie have a future interest here? No. So who has the present interest? And who has the future interest? Ooh, it's different. Why is number 2 different from number 3? Why did you change your answer to future interest there? Correct. Correct. All right. Example number 3 is what we call a tenancy in common, right? Keep your terminology straight. Students will often confuse joint tenancy and tenancy in common, and they'll say the worst. And I've done this before, and I hated myself because I was so mad at myself. They'll say joint tenants in common. Trust me, you're going to want to say it. It's like possibly reversion, right? They'll say joint tenants in common. That's not a thing, right? If you find yourself writing in your notes joint tenants in common, you've made a mistake. That's not a thing. It's not a property interest. So number 2 is a tenant in common. So we would say for the present interest that Alex and Baker are tenants in common, where they have a C for Jen's question. Alex and Baker have a present interest in tenancy in common. Okay. Alex and Baker have a present interest in tenancy in common. Okay. Everybody with me? Okay. Now, the biggest difference between the joint tenancy and the tenancy in common is what happens upon death, right? The biggest difference between the joint tenancy and the tenancy in common is what happens upon death. With a joint tenancy, you have this thing, this right of survivorship, which means the surviving tenant gets Blackacre. But there's no right of survivorship with a tenancy in common. Instead, the person who dies, right, their interest goes to their heirs. Right? So the person who dies, their interest goes to their heirs. Okay? Everybody with me? So in this example, who actually has the future interest? Right? It's a little tricky, right? Because the future interest is kind of split, right? The heirs of Alex and the heirs of Baker, right? They're both going to have a future interest at some point. Because when Alex dies, Alex's heirs step into the shoes of Alex, right? And then when Baker dies, Baker's heirs step into the shoes of Baker. But what's weird, right, is the heirs become co-tenants with each other, right? The heirs are now tenants in common with others. The death does not destroy the tenancy in common. It merely changes who the tenants are. Everyone get that point? It's very hard to wrap your head around, right? The death does not destroy the tenancy in common. With number two, as soon as one of them dies, there's no more joint tenancy. It's just a fee simple absolute, right? It's a fee simple absolute, whoever survives it. But with number three, the tenancy common survives. It remains. You're just putting different people into the relationship. Yes, sir.
The property is divided further than the line.
Yeah. I think Max is a fair point. So imagine a person has one heir, right? Then it's really easy, right? Then one just slots in. What if a person has 25 heirs? Right? Let's say you die without a will, and you have 4 kids, 8 grandkids, 15 great grandkids. Imagine you're an older person. Guess what? Alex has a lot of new neighbors, right? These become absolutely unmanageable when a person dies intestate, when dies without a will, when they have a lot of heirs, because everyone can lay claim to it. So creating a tenancy in common may seem like a really good idea when you have 2 people, but when one of them dies, you're screwed, right? It's going to become an absolute disaster. And what usually ends up happening, and we'll talk about this later, is a partition sale, where they just sell the property and they divide the proceeds up by the shares. Okay, so everyone see again, it's kind of hard to write what the future interest is here, but just so you know who has it, it's going to be either the heirs of Alex or the heirs of Baker. And they step into the shoes, right? They step into the shoes of whoever died. Everyone with me? Yes, Shadi.
Hey, like one or the other.
Yeah.
Person who died first interest and their heirs. First guy's still living. When he dies eventually, it goes to his heirs.
Correct. Yeah. But again, the important point is they become co-tenants with each other, right? And I think Max's point was well taken. If there are like 10 or 15 heirs, you got a lot of new neighbors on your property because they're a co-tenant with just as much rights as you have. You can't exclude them. All right. Okay. All right. So let's go back a bit to example number 2. And I want to talk about how you actually create a joint tenancy. Creating a joint tenancy is not easy. You have to sort of jump through some hoops, 4 hoops in particular. These are called the Four Unities. It's sort of a weird phrase, right? But there are these 4 interests, these 4 requirements that must be satisfied in order to create a joint tenancy. If you don't create these 4, if you don't create these 4 unities, you do not have a joint tenancy. Let me say this a little more precisely. If you fail to create these 4 unities, you actually have a tenancy in common, right? So think of like a hierarchy, right? The joint tenancy is kind of up here, and the tenancy in common is like down here. If you don't meet all the requirements of the joint tenancy, you sort of like shoot some ladders, right? You go down to the tenancy in common. So you have to be very careful that you use these 4 unities when you create the interest. Additionally, if at any point one of these unities is broken or say severed, shoot some ladders. You go down to the tenancy in common. So anything that starts as a joint tenancy could easily become a tenancy in common. But it doesn't go the other way around, right? You can't go up, right? You can't convert a tenancy in common to a joint tenancy, but you can go down. You can take a joint tenancy and make it into a tenancy in common. See that relationship? You can go down, you can't go up. Once you lose the right of survivorship, it's gone forever. You don't get it back. So it's risky. All right, so let's talk about these 4 unities. And there's an acronym that a million lawsuits have used to remember these. You're not you're not the first. TTIP. Millions of lawsuits have used this over the years. TTIP. Okay. And I'll give them to you. We'll discuss them in a minute. Time, title, interest, possession. I'll put an extra I in there. I'm sorry. Not Pinterest. Interest. Time, title, interest, and possession. Okay. All 4 of these unities must be present when the joint tenancy is created. Okay? Time, title, interest, and possession. Let's walk through these. All right. The first unity, and let's use example number 2 as an illustration. The 2 joint tenants must receive the interest at the same time. The interests are conveyed simultaneously. Again, the 2 joint tenants receive their interest at the same time, or we say that the interests are conveyed simultaneously. Okay. If I give, Nicholas the joint tenancy today and I give it to Will tomorrow, that doesn't work. It has to be done at the same time. Okay. and not just at the same time, but in the same document, right? In a single conveyance, right? The same instrument or document conveys the title, right? The same instrument. An instrument is just a fancy word for a document, a piece of paper, right? Or like nowadays, right? But the same document is conveying the title. If I write one document to Nicholas and I write one document to Will, that's not going to cut it. And I mean, just think about before computers, this makes a lot of sense, right? Forgery was rampant. There wasn't good record keeping. The best way of showing that they received at the same time was just the same piece of paper, right? If you have a piece of paper, it says, I'm giving Nicholas and Will a joint tenancy. It's right there, black and white, right? You can see it in front of you. All right, so you have your time and your title. These are the easiest ones. Now, poor Will asked me about the other one, the interest one, which I hate talking about. You must convey the same interest to the joint tenants. Tenants must have the same interest. If Alex has a 1/3 interest in Blackacre and Baker has a 2/3 interest, for example, they're not joint tenants. They must have the same interest. Okay, now, I am not going to write fractions on the board. And the reason why is it confuses students so badly, right? If I say that they have equal interest, you might think, oh, that's easy. Josh owns 50% Blackacre and Sally owns 50% Blackacre. No, and it doesn't work like that because of the last requirement. They must have equal possession over the land. They each will have access to 100% of the parcel, 100% of the property, right? Every inch of the property is available to both of them. In other words, if we're joint tenants, I can't build a wall or a fence and exclude you. I have to give you access to the entire property. If I exclude you, I say, no, you can't come to this part of the property. Guess what? I've severed a unity. And my joint tenancy becomes a tenancy in common. If I exclude you, I deny you possession to part of it. Guess what? No more joint tenancy. We're back down to tenancy in common. The reason why I hate giving fractions, and Will sort of asked me about this a few minutes ago, is because people think, oh, well, that's easy. 50%, he owns 50%. But if you think about it like that, you start getting to the trap of, well, you don't have the entire property, right? You don't own all of it. They both own it together. So I would encourage you, to the extent possible, not to think about fractions. Right? Don't, I think going back to middle school, right? Try not to. We may have to in a couple questions, and I'll do it if you force me to. But the fractions, I think, do more harm than good. Right? Because they both have access to the entire property. You can't exclude a co-tenant, or I'm sorry, joint tenant from part of the property. All right, again, to create a joint tenancy, all 4 of these unities must be present at the time the interest is conveyed. You use a single piece of paper, you sign at the same time, and you give them all the interests to all the property. Okay, so the first 3 really exist when the document's created. But the 4th one's ongoing. If at any point you deny possession to some of the property, you sever the unity, you go down to a tenancy in common. Everyone's fine. Everyone get this so far? Okay. This topic is deceivingly complex. It looks simple, but it's actually not. And I'll lose you all in a few minutes. I'm just warning you. It happens every around this time. It's like I know it's going to happen, and I can't stop it. It's a very feeling of helplessness that I just have to sort of soldier through. It'll make sense later, but you'll momentarily lapse in a few minutes. Yes, John.
According to like
exclude someone from use of the property? Like, what if you just accidentally lock someone out?
We'll do a case next class, so not Thursday, but a week from today, where it involves locking doors, and we'll get to that next week. So just hang on for next week. I promise to answer that question. But this is an issue that's litigated, what John's asking about. All right, let's take a look at number 4. Number 4. Okay. It says, let me just make some more space so it's on the bottom. Blackacre. Okay, number 4. Blackacre from Ollie to Alex and Baker's joint tenants, period. Then we have a new sentence. From Alex to Chris. Ooh. Yeah, now it starts losing people. All right, so Camille, just at the beginning, it says from Ollie to Alex and Baker's joint tenants. Just up to this sentence. Are the 4 unities satisfied there, Camille? Walk through one at a time, please.
Always Alex to Baker, Tenancy at the same time.
Good. Number 1, time is good. What's number 2?
The title, I'm assuming it's the same document.
Yes, it is. And you know that it's in the same sentence, right? So it's on the same sentence in my exam, so that's good enough for you. Same title. Good. They have the same interest.
It does have the same interest.
And how do you know that?
Joint tenancy.
Yes, it tells you a joint tenancy. Those are the important magic words. Okay. What about number 4? Do we know?
No, it's not.
Correct. Okay, good. You said the right thing. We don't actually know if there's a full possession, but we presume there is, right? Unless I give you some facts about exclusion, just presume there's full possession. So the 4 unities satisfied?
Yeah.
So we have a joint tenancy. Okay, cool. Julius, so the very next sentence, right? It says, from Alex to Chris, what's going on there? Oh, is it a Wu-Tang shirt? I'm from Staten Island. Do you know that's where they're from? Okay. Anyway, go on. Sorry. You don't spend much in Houston. All right. No. Yeah. Staten Island's not famous for much. Most of it's not very good. So that's at least something that people know for that's positive. All right, Julius, go on. Why is it no longer a joint tenancy, my friend?
Well, I mean, with the 4 unities, it's no longer.
So which unity was severed here? Let's just be precise for a minute.
Oh, I'm sorry.
Kind of, but what's the eventually possession severed? What's the first unit to be severed though? Interest, correct. Yeah, that, you're not wrong, Julius, but the interest one's severed first. So what happens here in example number 4, when Alex conveys his interest to Chris, this a little bit bigger, it's hard to see in the back. Okay, there we go. When Alex conveys his interest to Chris, he severs the interest unity, right? When Alex conveys his interest to Chris, he severs the interest unity. Alex and Baker no longer have the same interest. They no longer have the same interest. And then once that unity is severed, we go down to a tenancy in common. So at this point, it used to be a joint tenancy with right of survivorship. But now we have a tenancy in common. There is no survivorship. Baker and Chris are now tenants in common. Right? Baker and Chris are now tenants in common. One second, Will. So just think about this. Baker is out of luck. Baker had this valuable thing, this right of survivorship. But because her joint tenant sold out, that's gone. So the heirs of Baker will get nothing, right? This will no longer be in Baker's family. Right? Baker will never get this in fee simple. Instead, Baker's family will always have to share it with the heirs of Chris. They're forever tied together as family members. Keeping a joint tenancy is hard because if one of the joint tenants decides to go rogue, they destroy the relationship. And that's their right to at any time. We'll get to marriage in a bit. Marriage is a little bit different. But if they're not married, They can destroy it at any point. Will?
Wouldn't the time and title also be separate?
Yes. Yeah. I mean, you're technically right, but the one that we say severs interest, that's usually the one that kills it because it's a different interest. But you're right. Really, when you sever one, all four of them get severed. So we focus on the interest prong. Okay. At any time, a joint tenant can sever a joint tenancy. All he has to do is convey it to a third party. We'll see in the other case, you don't have to do that in California. You can take a shortcut, right? But you can convey it to a third party, and that's sufficient to destroy the survivorship right. Again, when you destroy one of the unities, you destroy survivorship. That becomes very important, right? Because I give you a fact pattern with lots of things going on, but there's a conveyance that severs unity. You got to stop and think what's going on now. Now we have a tenancy in common, not a joint tenancy. See, this looks simple, didn't it? But it's actually a little complex. Yes, sir.
Modern day example, like what? Like,
It's a joint tenancy. I mean, same as it was 500 years ago. The property never changes, right? You have two people, maybe a married couple, maybe two friends, and they're given land as joint tenancy, saying, okay, I want you to live on this. Whoever outlives the other gets to keep it. That's what a joint tenancy is. I mean, the advantage of the joint tenancy is it's very easy, right? You don't have to go through the probate process. You don't need a will. It's automatic. Once A dies, B gets it. Or once B dies, A gets it. There's no need to go through a lengthy process. But with a tenancy in common, there is a lengthy process. You have to decide who are the heirs, et cetera, et cetera. Okay. So let's take a look at example number 5 on the sheet. All right. Creating a tenancy in common is actually very easy. With a tenancy in common, you don't need the four unities. They don't have to receive it at the same. Sorry, they do not have to receive it at the same time. You can use different instruments or different titles. With a tenancy in common, you can have separate interests. Maybe tenant number 1 has a 2/3 interest. Tenant number 2 has a 1/3 interest. You can do that, right, with a tenancy in common. That's just fine. But the fourth unity must be present. Okay, this is important. Even with a tenancy in common, the fourth unity must be present. Each tenant must have access to the entirety of the property. One tenant cannot exclude the other tenant from part of Blackacre. Again, the first three unities are not necessary, but the unity, possession, is necessary for the tenancy in common. One tenant cannot exclude the other tenant. Everyone with me? Okay, now look at example number 5, please. In example number 5, there's severance. You have a tenancy in common between Alex and Baker. Alex conveys his interest to Chris. Okay? What happens here? Chris steps into Alex's shoes. Chris steps into Alex's shoes. Now what happens is that Chris and Baker are tenants in common. That's the present interest. Right? Chris and Baker are tenants in common. So the structure, this tenancy in common, the structure remains the same. You're just slotting someone else new into the structure. Everyone with me? And again, the future interests will be the heirs of Chris and the heirs of Baker, right? When Chris dies, Chris's heirs slot in. When Baker dies, Baker's heirs slot in. Okay. Everyone with me? Yes, Will?
Just say Alex and all the
Well, Alex has no interest in. Yes, correct. Alex has no interest. Ollie has no interest. That's correct. Everyone with me? Okay, let's go down to the last one, number 6. This is what we call the tenancy by the entirety, which involves married couples. Now, not every state has tenancy by the entirety. California, which is the subject of the case we read today, doesn't have it. People say, well, Josh, don't you have to? No, no. If you're a married couple, there's no obligation to have a tenancy by the entirety. A married couple can create a joint tenancy. A married couple can create a tenancy in common. To create a tenancy by the entirety, you must use specific language. You must choose to create it. There's no obligation to. Okay, so look at example number 6. Blackacre from Ollie to Alex and Baker as tenants. Oh, sorry. Blackacre from Ollie to husband and wife as tenants by the entirety. Right? The tenancy by the entirety is very similar to the joint tenancy. They're very similar. The tenancy by the entirety has a right of survivorship. So when husband dies, wife gets Blackacre in fee simple. And when wife dies, husband gets Blackacre in fee simple. This was usually a very useful way to preserve a family homestead, right? That when you have a married couple living together, when one spouse dies, the other one gets it in fee simple. There's no probate, there's no lengthy process. It also matters for something you may not think about much, which is debtor law, right? We'll cover this later. Generally, if one spouse generates debt, right, gambling debt or doesn't pay back a loan or something, the homestead was protected, right? That was part of the rules of bankruptcy. And keeping it something by the tenancy by the entirety keeps the home in the family, even if there's debt, if there's a collection. All right. The tenancy by the entirety is subject to the same 4 unities, right? The same 4 unities: time, title, interest, possession, plus one more: marriage. No, marriage. Princess Bride, right? Okay. Marriage, right? Marriage. A couple of you saw that movie. I thought it was overrated. Actually, I didn't like it that much. I know it's popular. People love that movie. Princess Bride. You love it. I thought maybe I didn't actually see it till a couple years ago. I didn't see it as a kid, but then again, I don't know. I didn't like it that much. Right? The tenancy by the entirety has 4 unities plus marriage. So you must use the same conveyance at the same time, use the same title, the same instrument, give the same interest. They must have equal possession, and they must be married at the time of the conveyance. They must be married at the time of the conveyance. If you have a joint tenancy and you later get married, it doesn't suddenly become a tenancy by the entirety. It doesn't go up, right? You have to be married at the time of the conveyance. There's an example in the book somewhere where it says they create a tenancy by the entirety and get married like a week later. That doesn't work, right? That's not enough. You must be married when the conveyance is drafted. You can't get married. You can get married later, but it's not a tenancy by the entirety. It's just a joint tenancy. Now, there's a big difference right, between the tenancy by the entirety and a joint tenancy. In example number 4, let me scroll back up. Right, in example number 4, a joint tenancy can be severed if one joint tenant conveys his interest with a third party. Again, in example 4, Alex severs the joint tenancy by conveying to Chris. But with a tenancy by the entirety, one spouse cannot convey his interest to a third party. With a tenancy by the entirety, both spouses must agree to the conveyance. Let's say it again. With a tenancy by the entirety, both spouses must agree to the conveyance. Right? Like any good married couple, they both have to agree, right? Or something like that. You can't make a unilateral decision. In other words, you cannot, pardon the French, screw your spouse over, right? You can't just say, ha, I'm going to sell my interest and give you nothing, right? No. Both spouses have to consent. It's a special relationship, which is why it's not for everybody. It's controlling, right? If a couple actually goes ahead with a tenancy by the entirety, they are removing the possibility of one spouse selling his interest. The only way to sever a tenancy by the entirety is divorce. I'll get to death in a minute, all right? The only way to sever the tenancy by the entirety is divorce. If you get divorced, it goes down to a tenancy in common. Again, if the couple is divorced, it goes through a tenancy in common. So, Josh, why isn't it a joint tenancy? I don't know, but that's the rule, right? If you're getting divorced, you kind of just put the lowest rung, right? If there's divorce, it goes down to tenancy in common. Someone always asks, I don't have a good answer. I don't know why. That's the rules. Of course, if one spouse dies, if the husband dies, for example, the wife gets it through survivorship. So really the only way to end this tenancy in common, this tenancy by the entirety, is a divorce. That's how you terminate it. Questions? Yes, John.
So for the back to the students in common,
Okay.
we're talking about future interest. All we need to put is, like, for example, heirs of Chris and heirs of Baker, or is there more to that sentence?
Yeah, you're asking me a good question. There's not really a good way of describing it, right? Because you don't know who it's going to be. So I usually write like that. That's how I do it, but there's not a good way of doing it. When I usually test these sorts of questions, what I usually ask is what happens upon the death of B, or what happens in the death of A, and that's usually how I ask it. Questions so far on 1 through 6? Yes, Laura. Well, I said that for a lot of times, right? I mean, I think you have to be more specific. People die in every class.
I don't think I can get worse. Can you tell that I was like,
Oh, I think I remember. With the tenancy in common, right? If a person dies without a will, right? So I think that was example number 2 or 3. Yeah, 3. Right. So this one, right? If Alex dies without a will and he has like 25 heirs, Baker's screwed, right? Because Baker now has 25 new roommates, 25 new co-tenants, right? Again, I had a student sat right over there a couple of years ago, and his family owned some land in West Texas that they found valuable oil on, and it had been set up as a tenancy in common a couple of decades ago, and then basically everyone died without wills. So there were literally hundreds of heirs who all had a stake to the claim, and it was a disaster, right? And so basically they're forcing the sale, and they chop up the proceeds. But once you get past 1 or 2 co-tenants, it gets really unmanageable. It's hard to. I mean, you guys have roommates, and you get sick of roommates after a while, right? You have to sort of move on. Spouses you're sort of stuck with, but not really, right? Properties forever, even if relationships are not. Yes, Ryder.
So, have you kind of really learned later in the other cases where, like,
Ooh, you did it. You said joint tenancy in common. That's not a thing.
Okay.
It's okay. No, I'm glad you did it. So trust me, you're gonna want to say it.
So let's say if we have an example where we have a fiance pair of a couple that.
Yeah, if they're engaged,
Yes, they're about to be
Fiance,
engaged,
okay.
but they're not
married yet. Correct.
They purchase a house, they have a joint tenancy.
Yeah.
Can they then convey to themselves future on to then have a tenancy in the entire?
Oh, okay. So ask me the question after you do the riddle. No, you're asking me a good question, but let's do riddle v. Harmon, and I'll come back to your question later. I promise. All right. I want to do the California case. Is there any other questions so far, Mar? I forgot to do it. I'm sorry. You're right. I realized that as I was doing number 5, and I forgot to. Sure. So the present interest in number 4. Thank you. Always remind me. I want to make sure your notes are clear. Who is it? Alex and Baker are joint tenants. Okay. And then you have this conveyance. And then you have Chris and Baker are tenants in common. And we'd say the future interest are the heirs of not heroes, the heirs of Chris and heirs of Baker. I think that's right. That make sense? Yeah, I realized I forgot that one. I'm sorry. I think I said it out loud. See, initially, just to make your notes fully complete, there was a right of survivorship, and that was extinguished because of the conveyance of Chris. Number 4. All right, let's do the who am I up to? Diddy, I think you're next. Okay, can you give me the facts, please, in Riddle v. Harmon? This is a case where the couple doesn't like each other very much. Good. Well, before her death, what happens? What does Miss Riddle realize before she dies? Yeah, why should she go see an attorney? Okay, so you're being very generous, sir. Why does Miss Riddle not want a joint tenancy? What is she worried about happening? That's her who? Her husband?
No.
Oh, her heirs. Right. I'm sorry. So she wants her heirs to get the property, right? With the joint tenancy, who would get the property upon her death? The husband. But who does she want to get it? Not her husband.
Yeah, that is.
Okay, very good. Thank you. All right, so here's the situation, right? You have a woman, husband, wife, they're married. And I take it's not a happy marriage. You guys they don't like each other. We can nod our heads at that one. And at some point, Miss Riddle, her name is Frances. Frances learns that they have a joint tenancy. And upon her death, I think she was kind of ill, Blackacre would go to the husband, and she flips out. Right? She's like, whoa, 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 whoa. I don't want this going to my husband. I want it to go to my kids, my heirs. Right? So, Maria, what could Frances have done to terminate her joint tenancy? What would be the usual, the usual way to disseminate, to destroy a joint tenancy?
Usually you would convey it to third party.
Correct. She could convey it to a third party. But what's the risk of conveying it to a third party?
That they would have to convey it back to her.
Are they obligated to convey it back? No. Okay, very good. Thank you, Maria. Right, so historically, this is sort of Ryder's question, right? Historically, the way you destroy a joint tenancy is the wife would convey it to a third party. That severs a tenancy. And then the third party conveys it right back. Now, there's no requirement they do this, right? They can say, haha, screw you, I'm going to keep Blackacre, right? But this is done usually very formally, right? So let's say that you have a lawyer, and the lawyer's secretary becomes that third party. And this is a trustworthy person, And they're basically accepting the property for the sole purpose of destroying the joint tenancy. They convey it back to you. This was called a straw purchase. Straw, S-T-R-A-W. Think of like a straw man, right? It's not a real person. Remember Wizard of Oz or the straw man, right? It's a fake person who's there for the sole purpose of destroying the unities. So you convey it to the secretary, and then she conveys it right back to you. But that's kind of complicated. It requires a lot of time and money and effort. And it seems that Miss Frances was old and dying. And maybe she didn't know how long she'd live for, right? Maybe she thought she was on her last legs and they didn't have time to arrange this. So they tried something different. Astrid, what does Miss Frances try to do? She does something a little bit different than what you usually would do.
Trying to protect himself.
Wait a minute. How do you convey something to yourself? How does that even work?
He was a lawyer.
Yeah, she is a lawyer, right? The lawyer gave her some advice, right? What did the lawyer tell her to do? No, you're right. What actually did the lawyer tell her to do? That's good, Matilda?
I think she made a deed for the company,
Correct. And what did the deed do?
said that the purpose was to terminate the joint tenancy.
Correct. And specifically, how did it accomplish that? James? You're all right.
I think they just created the deed in themselves and then just deeded it to herself.
How do you, that's what I'm asking you, right? How do you deed it to yourself? How's it even, what's that even mean?
I mean, maybe it was more about just them putting it down on paper that she didn't want a joint tenancy.
Yeah. All right. Let me try this a little differently. You're all right. You're all giving me the right answer. So let's think in terms of the bundle of sticks, right? Right. We had a joint tenancy, right? So the husband had one stick, the wife had another stick, right? How do you give yourself a stick, right? How can this even be done, right? It's yours. How do you like? If you give it to, give it to Nicholas, Nicholas gives it back to me. Okay, there's an actual transfer. But the lawyer said, and I'll read the quote: Frances granted to herself an undivided 1/2 interest in Blackacre. And they're right. Astrid and Matilda explained it. The deed says the purpose of this document was to terminate the joint tenancy between Frances and Jack. That was it. Can you do that? Now, Monica, let me ask you a question, please. You're a lawyer in California, right? And you study the cases, you pay attention in property class, you know the rules. Would you have given your client this advice to do this sort of funny, self-transaction? If you were the lawyer for Miss Frances, would you tell her you could do this?
Probably not,
Why not?
because, well, they talk about one of the president cases where we did that and they've not.
So in other words, in California, there was direct precedent saying you cannot do this.
Right.
And the lawyer did it anyway. Was this lawyer like an idiot? I mean, what was going on here?
He was just a little experimental.
Okay. Oh, I love your answer. So she says, that was a good answer. He was being experimental. Brock, should lawyers be experimental? Probably not. Why not, sir? Except in California. So I'll give you a rule of thumb. If you have any case from California, they're about to reverse the common law. I swear, it's 100% true. Any case in your book, I think probably in any of your books, that's from California, they're going to reverse the common law rule. So maybe if you're a California lawyer, it's like, screw it, who cares, right? Tell it the common law. But I think Monica and Brock make fair points, right? I mean, this is something that you're not sort of aware of, but it's very important. Lawyers have a duty of competency. And if you don't abide by that duty, you can be sued, what's called legal malpractice. Medical malpractice, right? It was the billboards inside the road. Were you a loved one injured in a medical procedure, right? If doctors screw up, there's malpractice. If you all screw up, it's legal malpractice. And I think, and maybe I'm wrong, maybe I shouldn't say this, but a lawyer who goes experimental, use Monica's word, is putting herself at risk of malpractice, right? If there's a directly controlling precedent that says you cannot do X, and then you advise your client to do X, guess what? You can be sued for malpractice. Imagine this case came out the other way, right? Imagine the case came out the other way. The court said, no, you can't do this. We're abiding by our precedent. Who would get it? The husband would get it. And then what would happen? The heirs of Francis would sue the lawyer for malpractice, saying you gave bad advice, right? If you had done the straw with the secretary, the straw purchase, we'd be fine. But you screwed up. So you can't do that. Again, just sort of keep these things in mind, right? When lawyers get experimental, to use Monica's word, it creates potential risks of malpractice. And you don't want that, right? I mean, you don't want every month the Texas is a bar journal, right? And they always list people who have disciplinary actions against them. You don't want your name being listed there. I check it every now and then. I'm dreading, oh, please don't let me be my former student. Please don't let me be my former student, right? Because I'm like, oh no, hasn't happened yet. I don't think has not happened yet, but I'm always dreading it. Charlie, is a hand up?
Yeah, that's what we're wondering about. You know, like, why did they do this? Or maybe the lady was kind of pushing for this particular.
I suspect. Okay, so let me give you my speculation. This woman was keeping this secret, right? She didn't want her husband to know, obviously. It's actually a very weird thing. People don't discuss their, how do I put this gently? It's much easier to just die and say nothing than to actually have this tough conversation during life. And very often people die without wills because they don't have these difficult conversations, right? Like I think Aretha Franklin and others have died without wills. Prince, people die without wills because they don't want to have those difficult conversations. It's tough to talk to them and say, you know what, husband of 50 years, I don't love you anymore. I want this to go to my kids. The more people you involve in this process, the more likely is the husband finds out. So my theory, which I have nothing to back this up on, is that the wife said, I don't want to involve anyone else. Maybe the secretary blabs, right? Maybe there's a recorded conveyance, right? If the more people involved, the more likely the husband finds out. The husband had no idea. I mean, this happens a lot. I mean, hopefully with none of you, but if you're a probate lawyer, family members are shocked when they read the wills. Like, wait a minute, my father left me nothing. I thought everything was great between us. People don't like talking about these things, rather just die and have the lawyer deal with it. And when you have the straw transaction, it creates records, and records that can maybe be discovered by the husband somehow. That's my theory. I don't have an answer for you, but
Lawyer gave her good advice. She said, I'm going to go with this, understanding what the risks are.
well, look. So I mean, that's another issue. What if your lawyer tells a client the precedent says you can't do this, and lawyer says they want to do it anyway? The lawyer can withdraw. You don't have to take a case. You say you're asking me something that's against the state law. I'm going to withdraw. I'm not going to either fire me or I'm going to quit. Right? Again, when you put your name on a document, you're putting your reputation on the line. And I try to make this point in this class. Right? Your name is worth more than any client. Whatever they're paying you is not worth your reputation. If you lose your old license, you're toast. So I don't know if this would be enough to get disbarred. I don't think it was, because I mean, maybe the lawyer said, well, we want the challenge, be experimental, to use Monica's word, right? You're not like committing a forgery. You're not committing like a fraud on the court. But you run a risk when you do something against precedent, because it shows perhaps you have poor judgment. But this is California, so everything goes, right? Whatever. At common law, and this was the precedent in the state, you could not unilaterally terminate a joint tenancy. You cannot unilaterally terminate a joint tenancy. Francis would have had to use a sort of straw transaction with the secretary to do it. So under California law, Tyler, did this conveyance to herself have any effect? None. Was there still a joint tenancy? Was there still survivorship? Okay. So the husband says, wait a minute. It's very nice for this conveyance, has no legal effect, right? It's just a piece of paper. There's no legal effect. our joint tenancy survives, and we have right of survivorship. All right, everyone with me? But blessedly, we're in California, and the California court reverses this common law rule. And this is a very common sort of way of thinking about these things, right? The court says, well, this straw rule is old, right? It's based on livery of season, right? The idea that you can't give yourself a stick, right? You can't give yourself a clump of dirt. You have to give the clump of dirt to someone else, and someone else gives you the twiggle, and they give you the clump of dirt back. That doesn't work. Think of the midterm question, right? The sort of pros and cons of relying on old law. This would be a case you could cite on that question, right? This is sort of case you can think about, right? Here, the court's expressly saying we do not want to be bound by the rules of feudalism, right? The rule's obsolete, and we'll no longer follow it. So ancient vestiges, this livery of season, should be abandoned. The court says the joint tenant should be able to accomplish what he wants to accomplish without using these sort of legal fictions, the straw purchase. Therefore, the court held the joint tenancy was severed. They had a tenancy in common, and therefore the heirs of Francis inherited Blackacre. And now just think of this for a second, right? The father's litigating against his kids, and now they're tenants in common together. Isn't that messed up? Right? This family must have really hated each other, right? Because they're fighting in court, and now they have to live together. Do they even want to live together? Why do you want this? I mean, so some of you have done family law before. I think maybe yeah, but people hate each other, right? It just gets really bitter among family members. It's ugly. Money and property never work well with family. I have no actual thoughts on this issue, but it makes me sad that they're so bitter against each other and they won't even talk to each other about their dying. Yes, Courtney. Oh boy, yeah. Do not ever treat California, New Jersey as majority. New Jersey's the same. So everything's legal in New Jersey, right? If you have any New Jersey cases, just presume they're minority, that they're reversing the common law. It's true in every case. We'll do some Jersey cases. Jersey and Staten Island are close enough. I can talk smack about them. I have no license to talk about California, but I will. Is that a hand?
Wait, and it's, I don't think it's somebody else other than yourself.
Correct.
Does that other person have to know or be there at the same time? Like,
You talking about a straw transaction?
if you just said, well, no, like, if we're trying to just destroy it, not bring back. Like, the example we did, when tenants, one of them gives it away, so it's away to somebody else, and then somebody.
Right. Well, that's a straw, right? If you give your interest to a third party and they give it back to you, that's a straw transaction.
Without,
Oh, I mean, yeah, that's fine. Give it to a third party, and it's not yours. You have nothing to show for it. You lose.
what she said,
But in this case, you wanted it back, so she gave it to interest to her kids.
would she not have just directly, instead of giving the deed to herself, written it out with her kids?
Yeah. Okay. Now I see your question. Sorry, I didn't see it before. Why didn't Miss Francis just give the interest outright to her kids? Right. That's Shadi's question. Why didn't she just give it outright to her kids that they would be tenants in common with the father? Because she didn't want to deal with it during her life. Right. Again, it's hard conversations. You don't want to deal with it during your life. Just wait till I'm dead. I think I might get this wrong. I think it was Snoop Dogg or someone who said, "I don't have a will because I don't want to deal with this crap. Let my kids deal with it." It's like the most selfish thing possible because it creates so much difficulty because you don't want to deal with it now. But a lot of celebrities just do not want to deal with it. It's just too complex, and then their estates basically destroyed. Who gets the money? Lawyers. Lawyers always get paid first. Don't forget that. Lawyers always get paid first. They always get paid. If you don't get paid, you keep the lights on. Keep on. Okay. Do I want to do this? Yeah, I'll do this next class. I'll do this next class. I don't want to do it now. All right. So Roddy, your question before. So let's say you have say fiancé, is that a word?
No fiance, you know.
I heard fiancé. Like, so you have an engaged couple, right? You have an engaged couple and they have a joint tenancy and then they get married. How would they have to create a tenancy by the entirety?
So husband to wife and wife to husband.
No, that wouldn't work. You need to have a single conveyance. We actually use a straw. You basically sell the joint tenancy to the secretary, and the secretary sells it back to the couple as a tenancy by the entirety. You can't do 1 and 2, 1 and 2 because it's not the same instrument. They're different instruments, right? So to answer Roger's question, you would literally need from the couple to a third party, and the third party transfers it back as a tenancy by the entirety. That's how you have to do it. Questions? All right, let me summarize. Maybe we'll get out a few minutes early to enjoy the lovely weather outside. I think it stopped raining though, right? Is it stopped raining? Yeah, it was scary this morning. I was like, whoa, you know. All right, so we have these 3 concurrent interests, right? The joint tenancy, the tenancy in common, and the tenancy by the entirety. The defining feature of the joint tenancy is the survivorship right. That's a very valuable thing to have. With a tenancy by the entirety, there is no survivorship right. When one of the tenants in common dies, his heirs step into his shoes. So you might end up having many different tenants in common. With a tenancy by the entirety, with married couples, there's survivorship rights. Okay. How do you create them? With a tenancy in common, all you need is just possession, right? As long as they have access to the entire property, you have a tenancy in common. But with a joint tenancy, you have these 4 unities. You must convey at the same time, convey the same title, have the same interest, and full possession. Tenancy by the entirety is a 5th unity, which is marriage. How do you sever these estates? Again, it's not really possible to sever a tenancy in common because if you sell your interest or someone else steps in, the only way really to destroy is have a court order of sale. You can sever a joint tenancy if one joint tenant sells his interest to a third party, or in California, sells it to himself. With a tenancy by the entirety, the only way to sever it is by divorce. You can't unilaterally sever it by one-sided conveyance. In advance of class next week, go back and look at, there's a question on page, I think it's 390. Memory serve, I think it's page 390. There are problems at 390. I'll do those in class next week. I don't want to do them with 2 minutes left. So again, no class on Thursday. I'll be around my office today. Thank you so much and have a lovely day. I'll see you next Tuesday.